So the session you're in is do's and don'ts of breach notification, how not to miss the mark. If that's not the session you were trying to be in, then you may want to exit now. There was a set of handouts as you came in on the table. Hopefully you picked those up. If they're, who's our room monitor here for this room? The outside?
There is a lady out there. She's putting it together and handing them.
Perfect. Okay, great. I won't worry about that. I just wanted to make sure you had the set of slides and to make notes, as well as our handouts for our discussion a little bit later in the presentation. So we'll go ahead and get started. Your presenters today, my name is Michelle Robinson. I'm the Deputy Director with the California Technology Agency, Office of Information Security. Just want to provide you a little bit of background and context of why I'm up here today. So I've been in information security about 12 years now, approximately, a direct security-related responsibility. Prior to my role in Office of Information Security, I was an information security and privacy officer in a smaller department or medium-sized department. And so I've had a lot of experience in incident response, incident handling, and specifically breach notification response and assisting agencies when they've had a breach. And our office is responsible for reviewing and approving state agency breach notifications. So in that realm, we've had a lot of experience in that. So then my co-presenter here is?
I'm Joanne McNabb with the Attorney General's new Privacy Enforcement and Protection Unit. And before that, with the former California Office of Privacy Protection, which came into being in 2001 and died in 2012. But one of the things that we published out of that office is a set of recommended practice guidelines on responding to a data breach, which is still available on the website and will soon be available on the Attorney General's website. And that was when the law first took effect in 2003 in July. And since then, we've had a lot of experience. I've had a lot of experience talking with companies and attorneys about their anonymous clients who hypothetically may or may not be experiencing what may or may not be a data breach that may or may not require notification, as well as with a lot of state agency people in trying to decide what's going on and what is the right thing to do.
Okay. So our session overview, we're going to do a quick review of the notification requirements, kind of the basics of the notification requirements, some additional notice content that we highly recommend and encourage people to include in their notices. We're going to talk a little bit about some of the notification challenges that you'll need to work through with your organizations, whether you're private sector or public sector, and the purpose of notification. We're going to talk what's the real purpose and need behind sending the notification. That's important for you to understand as you're drafting these notifications and sending them out to folks. And then we'll get into some examples, some of those that may have missed the mark, and some better examples as well. So that is our session for you today. So getting right into the breach notification requirements. I've taken these out of context and put them in what I feel is a more logical order and tried to simplify what the legislative statute says. So first requirement needs to be easy to read and understandable, so their language is written in plain language. The statute says name and contact information of the agency that's subject to having to send this notification out. So I translate that to on your letterhead, your official letterhead, okay, who you are and who your organization is. It needs to be dated, so data notice is what the statute says, so your letter needs to be dated. We've seen examples where the letter is not dated, believe it or not. A general description of the incident, so you need to describe what happened, and very briefly, succinctly, and again, written in plain language. Joan's going to chime in as we move along. We're going to kind of co-tag team this. So Another requirement, as you know the information at the time of notice, you need to include when the date of the breach, if that's known to you at the time you're making this notification, or if not, the estimated date of the breach, if you can decipher that from where you're at in your investigation, or the date ranges within which the breach occurred. So they want to see one of those three things within your notification. So describe when it happened, okay? And then there's a provision that whether or not the notice has been delayed due to law enforcement investigation. And a point to be made here, I'll let Joe make.
As the data breach notice law allows for delay if law enforcement says that notifying would impede an investigation. So it's not the fact that there is a law enforcement investigation going on. It's if law enforcement said, don't notify, it would impede the investigation. And in many cases, you would be wise to press on that, knowing that you're in this, push-pull about you want to notify promptly, but you don't want to notify too soon. So just the fact that law enforcement says don't notify now would impede the investigation. You can ask questions and make sure that that's true and then follow up on when is the best time. The longer the time lapse from when the incident occurred, and regardless of when you discovered it, and when you notify, the worse it looks to people, the more trouble it's going to make for you.
Yeah, and as an example, real life experience, working with there was a criminal investigation in this one particular incident, and so we did have a conversation, the department and I, with the law enforcement entity, and said, well, how about if we said this in the notification versus maybe some standard template type language? Would that be all right and not compromise your investigation? And they agreed to that. So it's worth having that dialogue so that you can get that notification out and meet that requirement sooner rather than later, as Jonas said. Okay, so additionally, you need to identify in the letter what types of data were involved. And in order to be helpful to the individuals, it's really important that you be as specific as possible with the types of data elements that were involved. And we'll get into the recommended actions later as it ties back to these, but it's really important to identify what data elements and the specific data types that were involved.
And so in some cases, you may want to even say the data did not include Social Security numbers if the kind of record you're describing might be understood to have Social Security numbers in it, but it wasn't. So sometimes you might want to even clarify that, not unnecessarily, but just if it could be assumed, because that will upset people more, obviously, and lead them to feel that they need to take different kinds of actions.
Okay, and then added recently to the statute is a notification or copy uploaded to the Attorney General's office if you are having to notify more than 500 individuals in a single incident. So if you've had one incident that results in your notifying more than 500 individuals, you're going to need to upload a copy of that breach notification to the Attorney General's website, and there's a whole plethora of those out there now.
Have you looked at them?
See them.
The ones that are posted? Yeah.
Some are good, some are not so good, John.
And we're going to be doing a study on the first year worth to see what can be learned from patterns. This is a better data set on breaches than just the ones that get reported in the newspaper, which is not all. Admittedly, these are the ones that eliminates a lot of smaller ones, but we should be able to learn some things about vulnerabilities or failures in procedures, whether there's typical vulnerabilities in certain industries. The first year will be kind of preliminary. Last time I looked, there were about 105 or 6. By year 2 and year 3, that data set should get more representative, and we should be able to learn even more, because I think everybody wants to know what can be done about this. Where are the weaknesses? What can we learn from others' mistakes?
How do you crosswalk that with the HIPAA?
have to, if you are a HIPAA-covered entity, so you have to comply with their notification requirements, so you're kind of reporting the same thing to two different places. They have a 500 plus threshold too, so. Oh, I hadn't thought about that. Should we? But the problem with that is, and this is what some of the studies on what we can learn from data breaches and the news stories you see is what's been relied on heretofore is primarily the ones that get in the news and the ones that are posted on the OCR website, the HIPAA-related ones. That always shows that healthcare has the most breaches, which isn't necessarily true. It's that they've been required to report them and make them publicly available for a longer period of time than other industries are. So I think we probably won't try and double count, but we might, that's a good idea. We might look just to make sure that we've got the California ones, and if we need to contact anybody.
One thing I've noted is a lot of people want to know what's, the risk, what's the, so I've breached, and, the total cost of all these breaches. Seen through the eyes of this day, I don't know if you are going to track, estimates, but I don't know if those are questions that you ask.
There are some studies that attempt to get at the cost. Symantec's annual breach report has some estimates, and that's based on a sample of their clients, but it's a pretty big sample. The Ponemon Institute also publishes an annual study. It's not a quantitative study. It's based on a benchmarking set of examples, but it's significant.
Well, that's to get funding for future things, especially if the state.
Yes, it's the information security officer's best friend, that law.
We need to know how much it costs so you can say, bad dog.
Well, use Ponemon.
I think the last study that came out, if I'm not mistaken, was $200 per person that you had to know for a breach. So
That was Ponemon,
It's an
214.
average. I think and that was as an average, but certainly I think from the state's perspective and being the central point for incident data collection, incident reporting for the state, we do see the costs vary significantly depending on the specific scenario and issues within that single incident.
In the Ponemon study, they're adding into that cost, including that 214, which I think was 2011. They're adding the cost of lost customers. We can't lose our customers. They may hate us, but we can't lose them. So it's different. I think there's a lost trust factor, but it's harder to estimate. Also, I think we're not very good at calculating the workload cost impact.
Okay. Additional notice content, it's not specifically required by statute. In fact, it says it's discretionary in the statute, but certainly we will be expecting that it be there in your state notifications, and we strongly encourage others to use it. So it will vary depending on the type of data elements involved. Most folks think that standard language about contact of 3 credit bureaus for every single type of breach notice is applicable, and that's not quite true. The recommendations for and the steps people need to take to protect themselves will vary depending on those data elements. So the first I have listed here, and do you want to?
Yeah, I just want
to
to
take over.
The point about what a fraud alert or a credit freeze. What they do is they protect against someone opening new accounts in your name. So if your social security number or even potentially your driver's license number was involved in a breach, that with your name and other easily accessible information, that's enough for somebody to go out and open a new account. If it's a credit card number or a debit card number or a bank account number, that only puts that single account at risk. So there's no benefit to somebody protecting against that if the breach was only of a single account number. So a fraud alert doesn't help. A security freeze doesn't help. Closing that account helps. That's the response for that. And when to unnecessarily give people this complicated thing to do, even though it's not that complicated, but it is complicated for people. It's putting a burden on them that's not going to benefit them. So we discourage saying, order your credit reports, place a fraud alert when it's only a single account number that was involved in the breach.
Yeah, so again, just re-emphasizing the importance of understanding what data elements were involved and what are the appropriate recommendations for that individual given those data elements or that data set. In health plan information, so you may not have heard there's this thing called medical identity theft. So if there's your name and your health plan identification, or there's been cases where membership benefit cards have been mailed to the wrong people, and there's an opportunity for someone to misuse that health plan benefit card to go in and get medical services under your name. So that's a different set of recommendations where you're informing the individual to monitor their explanation of benefits statements that they receive from their health plan provider. And if they don't receive those statements, then they're asking that health plan provider to provide those so that they can monitor more closely. So again, just an example of the different type of recommendation that you would be making there. It may be an issue where you're not required to make notification because a certain data element wasn't involved, but a good example of this is law enforcement, their home addresses, home phone numbers, if those are lost or stolen in a situation, your agency may be issuing a notification to those individuals so that they can maintain some heightened alert and awareness of, of their surroundings, if it's a personal safety type issue. Let's see, can we cover that sufficiently? Okay, so then you may also want to include what's the agency doing for the individuals. There may be an opportunity for your agency to do certain things, such as flag your case record. Maybe there's a way to do that if there is a potential for them, or for that particular case or benefit to be misused as a result of this unauthorized disclosure or situation. And then in some cases, the agency may wish to consider paying for credit monitoring and offering that as a service. That is no easy task. It does require you a contractual relationship with a vendor on a kind of an emergency basis, in which if you're going to include that in your notification letter and in a timely way. So it does require some significant coordination. It's not something your executives can just say, we want to do this, put it in the letter, and out you go. You have to have some processes and agreements behind that in which to support that. So
this would be a good opportunity for the state to get a sort of blanket contract for this service that others could draw on. Remembering what credit monitoring does is not the same thing as a fraud alert or a freeze. It tells you when someone has applied for new credit. It doesn't stop it. It just tells you promptly. So it's a benefit. It's not a prevention.
And it's also something that the individual would need to elect to do. You can't just do it on their behalf.
And then the other thing that is good to include is what you are doing to prevent this same kind of incident from occurring again. That people generally want to know that, and it's good to be able to tell them, in an appropriate way that isn't revealing information security secrets or anything.
Okay, so other notification challenges that you will encounter is, who's responsible for writing this letter in your organization? Is it legal? Is it communications, your public information office? So we have some recommendations here, and if you want to take this.
Okay, this is a kind of a breach notice letter is a kind of communications that in the public relations field is called crisis communications. You are delivering bad news. So when you're delivering bad news, there are some sort of rules about how to do it. It has to be really simple. So imagine somebody in shock and how you communicate to somebody. This is kind of what this letter is. However much you try and I'm not talking about you, I've seen notices that do this, waffle about, well, we don't really think anything bad's happened, well, the law makes me do this. At some point, the message comes across, something bad has happened with my information. So knowing that you're delivering bad news, the simpler you can make it, the less bureaucratic sounding, the more helpful you can make it, the better it will be received, knowing that it's never going to be well received. So what I always advise, and I've done these kind of things with companion attorneys, I come from a communications background, not from a legal background. I always say, have the communications professionals do the first draft and have legal edit. And of course, my attorney compatriots always say, no, the other way around. But you need both involved.
So the second point is tone of the letter. Oh, did you have a question, Steve?
Yes. What about situations where it's your own employees whose information is being disclosed, or if it's not a breach that happened within your premises, but say someone you contracted for services?
Two different scenarios there. One of the examples we're going to go over in a little bit is an internal departmental issue dealing with a notification to its employees. And then, so the second scenario was
it's
a
your service provider.
You definitely will be engaged with them in deciding who will do the letter, especially if your contract or agreement doesn't clearly spell that out. So the first thing I would do is recommend that you make sure those agreements spell clearly that out, who's responsible for a breach notification if a breach were to occur, and who pays, and all that should be worked out in your contractual agreement so that if something were to occur, you're not there. Unfortunately, I've seen cases where all of that wasn't clearly spelled out in the agreement. And so then it becomes okay, is the vendor going to step up and say, yeah, we did err here and we didn't fulfill our part of this and we're going to make notification. And I've seen many vendors do that. Many vendors just say, we'll make notification. You help us craft how you want to market and message it. And then others where, no, the department, and it becomes an issue to negotiate further later.
So from a communications perspective, putting the cost issue aside, which should be contractually provided for, from a communications perspective, it's not generally a good idea to have ABC Mail House, your provider, with whom your customer, your clients, have no relationship, of whom they have no knowledge. It might not get noticed. It will not make sense. So it may be, even if it's totally the third-party contractor's fault or responsibility and contractually they're going to pay for it, it may be better in many cases for you still to be the letterhead, the speaker in the letter. And yes, you can acknowledge this happened with, ABC did it, knowing that that's not going to absolve you in the mind of your customers. Blaming it on a third party with whom you have a contractual relationship, to whom you entrusted their sensitive information. You're not off the hook. But having them be the author of the letter, the letterhead, is I think generally probably not a good idea unless the customer is aware of them.
Right, and either way, you're going to have to explain who this third party is in the letter. If you're mentioning them and not just
saying it happened.
So good question. Thank you for asking that. Let's see. What did we cover? Tone. What not to say. Okay. What not to say. Some real common things we see that we would recommend not saying is we're writing to tell you about a recent security incident when it's not recent. It happened 6 months ago. Or it happened 30 days ago, even. So don't say it's recent when it's not. Another common little messaging thing we see is we have no reason to believe that your information's been accessed or misused. We understand that this may make your department feel better, but it doesn't help the individual on the receiving end, and it doesn't add any value to them, as well as it really can be challenged later because you have no idea Once it's left your control, how can you defend that you have that it wasn't accessed or that it wasn't misused?
On the other hand, I think there are some times where letting the facts speak for themselves, that is the message you're communicating. So, for example, this is a real breach. A healthcare entity emailed prescription information, including PII that met the standards for notification, to the wrong pharmacy. The wrong pharmacy received it, went, oh my gosh, this shouldn't have come to us. Called them up, told them about it, said, and swore on a stack of Bibles that they obliterated it entirely, and there's every reason to believe that. The entity that missent still decided that they needed to notify anyway, but they were able to say that, to say, we inadvertently mailed it to this other pharmacy, which called us right away and destroyed it. So that's just facts. So you didn't go on and say, so there's nothing to worry about, but sometimes the facts can help. And that's appropriate because you want to, when you can, diminish anxiety, when you can, legitimately.
See, last, addressed to whom? So in this area, it's like what's the salutation? Who are you addressing the letter to? You want to try and stay away from, if at all possible, the dear member or dear employee. You want it to be personalized to the individual. Dear Miss Robinson, we've had an incident that affects your personal information, so the letter is geared towards me and how I'm affected or how I'm impacted versus dear members, all of you, you're all impacted, and here's what happened. You want to try and keep it more personalized.
An example of when you can sort of overdo it is a breach of a large retailer, which before they had determined, an online retailer, before they had determined exactly who the affected parties were, they sent, feeling that they were being doing the right thing and then some, they emailed all of their customers to say that they had had this breach and they'd be notifying the appropriate ones later. Well, not good. It unnecessarily raises anxiety, and then all of the others who never received another notification, half of them called anyway to say, well, am I going to get one? How do you know when you haven't received it if you're going to? So you want to try and scope out the reach, obviously.
Christina, you had a question?
I was just going to add to that. It's also just good security practice because many of us have been taught if you receive an email or you receive a letter that just says dear member or dear customer, we ignore those emails, we ignore those letters, shred them. So
Good point.
So it's important to make sure that you are recognizing the person and the individual who's affected and not a large group.
Yeah.
Good point. All right. Joan, take it away.
Okay. I did a whole presentation on this just because I like this picture. I think they're Amish. So the whole notification process, in addition to being a legal compliance issue, is about helping people, about mending fences in a couple of senses, about helping the affected to mend their own fence, to recover, to protect defensive action, and the nature of the communication, the style, etc., is about mending your relationship with them in a difficult situation. I pulled these little things from a website from Twin Cities Jewish Network right when I was preparing this a while ago, and it just seemed amazing. It wasn't intended to be about data breach, of course. It was the Day of Atonement, but I think it's really apt for the mindset of someone doing a notification. So admit you are wrong, as all your legal counsel will say. There are ways you don't want to do this in writing, but that doesn't mean you can't say that you're sorry about what a difficult thing this is for people to deal with. It doesn't mean there are ways to say that you sympathize and empathize with the difficulty that this is for the notice recipients without accepting full responsibility for everything. But in your head, you have to get it that you were wrong. express sincere remorse. Know that people are going to be angry, and I'm sure we've all had the experience of the kind of phone calls that come in after a breach, and people are angry, and you have to be prepared for that and let them be angry. You can apologize, but they're still going to be angry. That taking the helpful tone is going to be the best way to move through their anger, and do whatever you can to make amends, to make restoration. That's things like what you can do on your side to protect them in the future, like flagging their record if that's appropriate, so that the next time something happens on that record, you'll take extra pains to make sure it's the right person, like telling them about how to do a fraud alert and helping them set that up when that's appropriate. And obviously, the last point, reflect on what you've learned. I believe that's probably even a policy requirement for state agencies, is to do a root cause analysis and draw the lessons and plan for the future. Some of that will get into the notice in many cases, but it's something that obviously we need to do.
Okay. All right. So now we're going to move to your handouts. The first one, the top of the letter should say before 351 words, 12th grade. And then on the back side it will say after 224 words, 8th grade.
So this is an actual notice. I'm looking at the before side, obviously, and okay, I'll look at it this way.
Bigger?
But that's right.
Okay.
Just looking at it, it's not up there, is it? Just looking at it, it's a bit dense. I've highlighted some of the things that are peculiar about it. The kind of information that was involved is username and email, and the billing address, which it says was encrypted, but it doesn't exactly explain what they mean by that. And that credit card information, but it was encrypted. And then they go on to give the advice as if it were a Social Security number breach, which may just be they don't know, but all in all, it's a little peculiar. Then there's a strange little paragraph, the last one, that the credit reporting agencies may require you to write them at a different address depending on where you reside and what you seek from them. That isn't even true. So it's not helpful. If that was true, it would have been, if it was appropriate to give that advice about contacting them, and if there were some special cases, you should then find out what the special addresses are for the people you're writing to and tell them, rather than this. And then finally, there is no toll-free phone number or even pay phone number for questions. And as you know, a certain percentage of people will call because they don't take in stuff in writing well. They want a human being to tell them what it said in the letter, and you want to be able to do that. So then when you look at the after, just by the look of it, you can see it's 125 or so words less. It's less dense. There's bigger font. The layout has more white space. The items, the little headers and the chunking, all of that is about readability. This has gotten down to an 8th grade level. The average reading level in the United States right now is 6th grade. 6th grade. Adults I'm talking about, not 6th graders. So to say nothing of language issues. You've got to give people a fair chance of taking advantage of the information in the letter in their language. The encryption issue is, remember the other one said that some of the information was encrypted. Well, if it was encrypted, why are you notifying? If by encrypted you mean something that is not true encryption, but it was coded in some way, it either was or wasn't encrypted. If it was encrypted, then there's no need to notify. If it wasn't encrypted, then don't even mention that, because it just confuses the whole picture. So for the redo of this, we decided, not having the facts about the encryption issue, that it wasn't encrypted, and so notification was necessary. Whatever they meant by encryption wasn't real strong encryption. the appropriate advice on what to do, close the account because it was a credit card account. And there is a toll-free phone number, and there is an expression of regret. We sincerely regret the inconvenience and concern this may cause you. You know, you could say that.
Yes, there are. There's a whole set of templates on both our site, the Office of Information Security's website, and the privacy website
Sites.
as well. So for state agencies, we have state information management manual with the requirements and decision-making criteria for when to do breach notice, and it also includes copies of those templates.
Can I can attest to, I'm Ivory from the Department of Public Health.
Hi, Ivory.
That is an absolutely great helping hand, and that's what we use in our office. And then, because I was going to say, when we do notification, we're required to send it to, the state ISO. And so in turn, there are many times they'll send back changes, and they are absolutely outstanding changes as to, of what they suggest. They don't say you have to do it, they say these are our suggested changes. But they're usually right on, and I've been using it for 5 years now. Well, I've been using it for at least about 2 or 3 years. I've been in the project there for 5. But it has been absolutely outstanding.
And Joan was instrumental in helping us develop that. So thank you very much for that testimony. Okay. All right, so moving on to the next example. The before and after are in 2 documents. The before, this is the incident involving unauthorized access to a shared network drive. So we're talking a state agency where employees could get to other employees' personal information, and they shouldn't have had access to those shared files. So you can see they started out with an internal memo, kind of to all staff, and the breach notification law requires individual notification by first-class mailing. So again, it needs to go out on letterhead to each individual directly. It can't be routed through interagency office mail and maybe sit in people's boxes for a while, which is kind of where this was going. Okay, they start out per state requirements. Okay, so what does that tell you as a recipient of the letter? Anyone?
You're only doing it because you're required.
That's the message you're sending. Okay, when you say that kind of thing, and you can see that they actually even say it again later on in the letter, so that's really important to them. But anyway, so you kind of see that. Let's see. They do have some squishiness here where it may have been compromised, it may have happened, it may not have. So again, be clear, this is what happened, and this is how you might be affected, and here's what you can do about it, right? Okay. Let's see. They do... Social Security number was involved, so it's appropriate to provide the information about the fraud alert and contacting the credit bureaus. However, they've done it in the letter, and we encourage you to use, if you look in the after, there's actually an enclosure, a one-page enclosure that we recommend people use because it has all the appropriate language that's been verified with the credit bureau, so we know it's accurate about their process and what the individual will go through. What we see is when people start putting that information in the letter, to save space, they eliminate some of it. And some of it that's being eliminated are key pieces to the instructions, or they maybe change the wording slightly where it actually becomes inaccurate information, and then will cause the recipient more confusion when they actually try and go through the process, and it's not following the steps you've provided. So, okay. So anyway, again, it's a little more dense than the first one.
And I haven't read this, but as a recipient of this kind of thing, as an employee, I would think this would be, I would want to know, what have you done to stop this happening, and who got fired? Now, that doesn't mean that we're going to say that exactly, but you need to address, when it's an internal thing, that an investigation is underway, or disciplinary action, appropriate personnel action is being taken, has been taken, will be taken, and here's how we're going to keep this from happening in the future. And wouldn't you want to know that?
And they do, in fairness, they do have some of that information in there.
You know, I was going to say, we had a year ago an internal, and it was not only internal with our, but it also affected our sister department's healthcare services. And we did it by email as well as because of it was a lot, $9. And because of that, we did the media. We also did post it on the website, as well as we set up a call center within the department because we knew that the
They did
employees,
substitute.
our employees and other employees were going to have a number of questions. And prior to that, we used the fax questions.
FAQs.
Through the FAQs, and we went through that and we tailored it to make sure our responses were correct. And so when they called into the call center, those questions were answered immediately, and there wasn't any. And we also we did credit monitoring for all those that were affected.
So you were going the substitute notice route because of the number of people affected.
Correct.
Mm-hmm. So that doesn't require individual letters sent by first class mail.
So one other thing we've seen departments use successfully and not so successfully are, and when it involves employees, and a large number of them are town hall meetings where you get them all in a room at key locations and answer questions, respond to questions they may have on that. But don't do it by telephone conference. That was the less effective one. Okay. Okay, so if we look at the after, it's a much shorter letter. The recommendations for fraud alert are on the back, or it can be a separate enclosure. And we've addressed all the information they need to address. And I think
No, we're okay.
we're okay. I did want to get to, because we touched on how you can use your websites and other communication outreach mechanisms. So I know we have a sample in your package of probably a widely publicized the Sutter healthcare breach, and some examples of how it's done properly on the website.
And the first one that has the picture of the woman leaning, notice the upper right, it's circled on that one, isn't it? So here it's easy to find, because I've gone to substitute notice places when you have to really hunt on the website. Like I remember the DSW shoe breach. Boy, good luck trying to find where they did that. So this was easy to find. And notice it doesn't say, here's where you can find out about the big horrible breach we had. You know, it's factual and important notice, and it's in red on the site for patients regarding stolen computer. So you can hear that's a little bit of, we were a victim too. But I mean, it's accurate, it's factual, and you can find it. And then when you click on that, it's
the other side.
That's the next page, or the other side. They've got quite a lot of information here broken up by section. So depending on who you are, you can find the right sort of information, and it also allows them to update as they learn more things, or add to the FAQs or something like that. So this is a very, I think, effective use of a website for substitute notice.
So I'll just add, when you're dealing with large population, you're having to notice a large number of people, you do want the FAQs, you want your call center prepared and trained on how to deal with those calls. There are a number of things, and the documents, both Joan's privacy or breach notification guidance and our requirements document, have all that laid out on how you can, one, develop a plan before it happens and how you'll respond, to walking you through at the time of the incident, kind of a checklist for you. These are the things I need to consider. Do I have these in place? Okay? Yes, in the back.
Who is the state agency responsible for oversight?
Office of Information Security, our office.
Oversight enforcement?
Okay. We have oversight by statute. our little office does not have enforcement. We report noncompliance to the state CIO. They have some, what I would call, enforcement mechanisms through other means.
Well, there is a law that can be enforced by attorneys general, district attorneys.
So the Information Practices Act, which the breach notification law resides in the Information Practices Act.
For state agencies.
And for state agencies, it's civil code. So within the act, there are consequences for department and individuals. A civil claim can be asserted against the department or the individuals, or both. That's one enforcement.
Or I'd have to get an attorney to talk to that. So at the state level, if somebody's not doing breach or fails to be breach, that would be
There is both a right of action of an injured party, and there are administrative and disciplinary and even criminal proceedings, all part of the Information Practices Act.
And now I know the Attorney General's office does take action against certain organizations that, private companies.
We enforce privacy laws.
They enforce privacy laws currently. From what I've seen, it's mostly been private sector, but that doesn't mean it can't be public.
I'm not a lawyer.
I'm not a lawyer either.
this is a disclaimer.
We're not lawyers. But we consult with them on these matters.
The issue on that is we are now seeing that the state is putting those same mandates as part of the scope in contracts, exactly the same thing. So even though, for example, Code 1798 doesn't apply to counties, they put it in our contract, and when we contract for services, it goes downhill to our contractors. So even though there's an exclusion, it doesn't mean we're all barred.
Well, right. We require that they put those in the contracts with you. Sorry. All right. Or you're welcome. Bye, Bree.
Mentioned earlier about contractors, if we have contracted companies, and we had, of course, working for public health, we have some, and one of the issues that we came up with one of our incidents was that before they knew what the rule was, but they went on ahead and did their notification, and what's in their notification, it did not have the necessary requirements. And so what we decided to do was to ensure that we have a center point, which turned out to be the center point. And so that, so that the department is not sued at some point, I draft all the letters, but I send it to the contract company as well as to the program and where the breach occurred, have them review it, and then we send it to the state ISO for that final review. So that there is a center point and that all the necessary requirements are in the letter and that it's all done the same. So that's just some advice.
Very good. So in the private sector sections, though, of the breach notification law, it's similar, right, for them, or do they have different requirements?
No, it's the same.
Okay, it's the same. All right. Okay, sorry.
So don't all these reviews start adding up to amounts of time and clocks ticking and things like that? Is there a time limit that we're supposed to?
It says something like promptly and without unreasonable delay. And so that's some of the tension is you want to do it as promptly as possible, not only because it says that in the law, but also because, especially in certain kinds of breaches, that the sooner people act to protect themselves, the sooner they know to act to protect themselves, the safer they will be, the less harm they will experience. So there's a push to do it. At the same time, there is a downside for all parties in over hasty notification. So one example was UCLA's breach of a number of years ago, where by their own policies, they were gallop, 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 faster, 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 and they knew, and they made a critical decision, and I'm not faulting them for this, but they knew the point where they had met their own internal timeline was we have to do it now. They weren't totally clear on the scope, but they made the decision, so they notified, the numbers have left me now, but hundreds of thousands of people. 2 weeks later, their further investigation revealed that there's only about 30,000 affected. So you can't actually undo that. I mean, yes, they did send a letter to the 200 and whatever, not you, which was good for them to do that. It turns out, not you. But it doesn't undo all the damage, But so you don't want to be too hasty, but you don't want to be too late. And it's just not easy.
So our guidance there is 10 days. Trying to do notification within 10 days, unless, again, there is some reason for not doing that. Determining the actual scope is an important element that needs to be addressed, if at all possible, before you make that notification. And that's a good example of why. So we do work with departments to turn those notifications around quickly. We ask that you call us when you have a notification you're sending for review, to make sure you get a live person on the other side of our phone that says, okay, we'll be on the lookout, and we'll turn that around quickly. I'm not a believer of handling incidents by email totally. The email is not typically a quick response mechanism, but not yet. We don't have anything published out there like that yet. I think if you were here for the opening, you heard Keith mention that we're working with the California Emergency Management Agency on their response information management system replacement. And what we're doing is automating the incident reporting process, and departments will be able to print those kinds of reports, generate those kinds of reports at their fingertips. Exactly, and in a non-identified way, what you look like compared to across state agencies. I will tell you, yes, we could do that. It would take some time. It's a very manual-intensive process right now, which is why we're really pushing hard to get it automated. Because it's really, we're basically, for tracking all these incidents, which have grown over the last 4 years that I've been doing it, is an Excel workbook. We don't have a database that can generate reports, so it's very manual and labor intensive to do the back end reporting, which one of my goals is to push the button and out it comes.
So I think just...
Oh yeah. So we did provide some resources in this slide. These are links that when they post it, you'll be able to get access to it. But again, our office website, I have some cards with our website address if you want those before you leave. And then privacy.ca.gov is still
so that's the old
site.
Office, and it's still up, and it will be going away, however. But we're recreating, we're pulling the resources on it onto a new section of the Attorney General's website, which will be available soon. And for a while they'll exist in parallel, then we'll kill the other one. And when you go to the old URL, privacy.ca.gov, it'll redirect you to the new one. And then we're also going to have a little sheet that you can download for those who have used those resources in the past, showing this document that was frequently accessed that used to be at this URL is now at this one, and so you can track them.
So we're infosecurity.ca.gov, privacy.ca.gov.
OAG.ca.gov.
And thank you very much
privacy.
for your questions, for being here. Enjoy the rest of the conference. Thank you.